Thank you for joining us. Welcome to WG University, Weber Gallagher's series of educational programs. This is our employment webinar series. I am Tracy Walsh, and I am presenting today with Charles Starnes from our Philadelphia office. If you would like to view this webinar again, share it with others, or see our other WG University programs, please visit the Weber Gallagher website, which is at www.wglaw.com, and you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is the FMLA certification process, overview, and practical tips. So let's get started.
Thank you for joining us here today. As Tracy stated, the focus of our webinar today will be the certification process for the Family Medical Leave Act. Before we get to the certification process, we'd like to provide a little bit of background about the FMLA, which is a federal law which provides eligible employees with unpaid leave. The FMLA also requires employers to maintain an employee's health benefits throughout that unpaid leave, and requires employers to restore their employees to their same or an equivalent job after they return from leave. Now, not all employers are covered by the FMLA. Covered employers include private employers with 50 or more employees, all public agencies, and all public and private elementary and secondary schools. Now, there are only a certain limited number of reasons that an employee is allowed to take this unpaid leave under the FMLA. Leave can be taken for the birth or adoption of an employee's child, or the placement into foster care of a child with that employee, the care for a spouse, a child, or a parent of the employee who has a serious health condition, which we'll discuss later. Employees can take leave for their own serious health condition, and it should be noted that there are special rules associated with care of a family member who is on active duty military status or a service member that is injured. We're not really going to discuss those today as they really don't relate to the certification process. Now, we discussed employer eligibility. For an employee to be eligible for leave, they must have worked for at least 12 months, although those 12 months need not have been consecutive and need not all have been for the same employer. They must have worked at least 1,250 hours during the prior year, and they must be employed at a work site where the employer employs at least 50 employees in a 75-mile radius. Now, FMLA leave can be taken in various types of blocks. It can either be continuous or as intermittent leave. Now, continuous leave would be taking your leave all in a single block of time up to 12 weeks within a given 12-month period. Examples for continuous leave include time off that would be taken to recover from some serious injury like a car accident or a slip and fall, or time following a surgery or the birth of a child needed for recovery. Now, intermittent leave causes employers a lot of headaches. It can be taken in separate blocks of various lengths. Intermittent leave can include a reduced schedule of working hours per day, a reduced number of working days per week, or simply taking off leave whenever a condition flares up. And this is commonly seen where you have an employee that has arthritis, diabetes, migraines, conditions where you can't really predict that someone will need off a set amount of time. Now, under the FMLA, employers can be subjected to legal liability if they do not comply with the law. There are two types of claims. The first is interference with leave taking, which includes, importantly for us today, the failure to notify an employee of their rights under the Act, and retaliation for seeking or taking protected leave. And now the damages that can be awarded to a prevailing employee include back pay for lost wages, front pay for lost income in the future, and these amounts together can be subjected to liquidated damages, which double the total amount of damages, sort of as punishment for the employer. Also within the FMLA, a prevailing employee could also be given attorney's fees and costs, which have a significant additional factor in when discussing whether or not to resolve or settle a case, as they can double, triple, quadruple the amount that an employee could win at trial.
So next, we would like to talk about the notice requirements. The FMLA is quite technical, it's quite specific when it comes to a number of factors, including notice requirements. And the FMLA actually sets forth requirements for notice by both the employee and the employer, so that both sides do have requirements with regards to notice. When it comes to an employee's notice requirements, if an employee's leave is foreseeable, then the notice should be provided to the employer by the employee 30 days prior to the start of the leave. A good example of this would be an employee is aware of a specifically scheduled surgery and can provide that notice to the employer. Or perhaps the estimated due date for the birth of an employee's child, and therefore the employee can provide that 30 days notice in advance. However, sometimes what can occur and can typically be more common is an unforeseeable situation. And in an unforeseeable situation, the notice by the employee should be given as soon as practicable. What can be practicable depends on the circumstances of the leave. There is no specific time frame that has been deemed practicable. So, for example, if an employee is incapacitated in a hospital, or for whatever reason is too ill to be able to immediately contact the employer, then that employee would be allowed sufficient time to recover and then provide the notice from that incapacitating situation. When it comes to the employer notice requirements, these are certainly requirements that are important for an employer to follow. When an employee does request FMLA leave in a very clear fashion, then the employer certainly then has to provide certain information to the employee. Sometimes, however, the employer learns that an employee's leave may be for an FMLA qualifying reason, even though the employee didn't specifically ask for FMLA leave. In either situation, the employer must notify the employee of his or her eligibility to take leave within 5 business days. So the employee does not need to specifically mention the FMLA, but should have provided some sufficient information which allowed the employer to have enough information to recognize that this employee may need FMLA leave. With regard to the employer's notice requirements, the employers should also provide written notice detailing specific expectations and obligations of the employee and explaining any consequences of a failure to meet these obligations. There are a number of items which should be included in this written notice to the employee. These items include any requirements for the employee to furnish a certification of a serious health condition and the consequences of failing to do so. And we'll be going over specifically the certification of serious health condition. Also, the written notice should include information about the employee's rights to substitute paid leave for the unpaid leave if the employee does in fact have paid leave available. And it should also advise the employee whether he or she must substitute paid leave for unpaid leave per a policy that the employer has. The written notice to the employee should also include any requirements for the employee to make premium payments to maintain health benefits. It is important to recognize that an employer is required to maintain the benefits of an employee who is on FMLA leave. So whether the employee must make premium payments to maintain those benefits should be included in this written notice to the employee. Also, if the employee is considered to be what's described as a key employee under the FMLA, and the statute itself does describe what a key employee is, and if the individual is considered by the employer to fall in the key employee category, this information should also be included in the written notice to the employee. Finally, this written notice should include the fact that the employee will be restored to the same or an equivalent job position upon return from FMLA leave, as this is an obligation by the employer under the FMLA to restore the employee. Finally, with respect to these initial notices that should be disseminated to employees, there are forms specifically on the Department of Labor website. We've provided that website to find these forms. Now, the website does represent through the Department of Labor that these forms are not absolutely required. However, it's important to note that the notice is actually required. So in other words, whether the form is used or if the information in those forms is placed in writing in a written notice to the employee. But either way, this information has to be provided in writing, and it is recommended that the forms be used. So the Notice of Eligibility and Rights and Responsibilities is also known as the Designation Notice, and that is a WHD 381 form, which can and best practices should be used. And as we indicated earlier, providing explanation by way of a letter is most helpful, and it should accompany the form to inform the employee of his or her eligibility and those requirements that we listed earlier. And this notice should also indicate to the employee that if a certification of healthcare provider is requested, that it needs to be provided back to the employer within 15 days.
Now we'd like to start talking about the certification process itself. To qualify for leave for a serious health condition, the employee or his or her spouse, child, or parent must experience an injury, an illness, an impairment, or a physical or mental condition which requires inpatient treatment or requires continuing treatment by a healthcare provider and more than 3 days of incapacity. Now we're using a lot of very specific terms such as incapacity, serious health condition. These are all defined by the Family Medical Leave Act and the regulations interpreting that act. Now, regarding certification and unforeseeable leave, employers should require certification from the employee's healthcare provider of the need of leave. The Act does not require this, but we would always advise a client to seek this certification as it's necessary to define what sort of leave can be expected to be taken, and simply provides you with the documentation that you can then refer to going forward. An employer may deny FMLA coverage if an employee does not provide a certification within 15 calendar days from the receipt of the request for certification, unless it's not practicable. As discussed earlier, what's practicable will depend on each specific case and whether or not the employee has the ability and the opportunity to provide the certification within the 15 calendar day period. Now, absent extenuating circumstances, if an employee fails to return the certification, the employer can deny FMLA protection for the leave following the expiration of the 15-day time period until a certification is provided. This means that after the 15-day certification period, there could be a window during which the leave taken is not protected, followed by a period where the leave is protected, after which the certification was given by the employee. Now, if an employee never produces a certification, the leave is not FMLA protected leave. And I'd like to discuss this 15 calendar day period. Employers should be very, very careful with this 15-day period for receiving the return of the healthcare certification from an employee. We would always caution an employer to refrain from immediately terminating an employee on the 16th day. If this does go into, if this was ever litigated, it could make an employer look as if they were eager to let the employee go, which could assist a plaintiff employee in their interference or retaliation claims. Now, in addition to that, as we discussed earlier, returning the certification in 15 days may not always be practicable. The employee could be incapacitated themselves, or simply that they have a medical provider that's not moving the certification forward in a timely manner. One thing we do advise employers is to always be consistent in your application of the 15-day period. Whatever policies you may have should account for the additional need or the need for additional time for an employee to provide the certification in cases of impracticability. But those policies should be created ahead of time and should be applied consistently throughout. Now, regarding the delivery method of any FMLA notices, letters, or forms, we always advise employers to send those via certified mail or through a carrier that provides delivery confirmation. That way you have some sort of proof and ability to track whether or not the employee received it on a given day. In addition, the Human Resources Department should stay in contact with the employee throughout this process and thoroughly document all communications and interactions. Now, if you have an communication through email, that's easy to keep track of. If it was by phone, we would always advise that HR take a note about this and place it within the employee's file.
So we initially talked about the designation notice form. And next, as we've been discussing the process, is the certification of healthcare provider. This is also a form that can and quite frankly should be used from the Department of Labor website. And again, we've provided that information here. This is known as the WHD 380E form. Now, these forms, once they're being disseminated to the employee, it should be accompanied by a cover letter that assists in explaining to the employee his or her rights under the FMLA and the requirements that we talked about earlier with respect to the 15-day turnaround time for providing the completed certification of healthcare provider back to the employer. And as I'm sure some or all of you may be familiar with, this document, the certification of healthcare provider, has several sections setting forth questions for the healthcare provider to provide answers to. And one of the important items there has to do with the essential functions of the job and what the employer can do instead of filling out and describing those job duties is to attach a written job description, and there's even a place for that on this form, so that when the healthcare provider is filling out this form, he or she is aware of what those job duties are that he or she is providing opinions about. So in addition to the letter providing some clarification on the use of this form, after that, and assuming that the certification is returned to the employer, there may be some issues that could arise for the employer that have to do with the form that the employer received back. So, for example, the certification that is returned to the employer may be incomplete. And when we talk about a certification being incomplete, we're essentially referring to actual questions not answered, actual sections of this WHD 380 form not being completed or fully completed by the healthcare provider. There could also be a situation where the certification is deemed insufficient by the employer because the information that was actually provided by the healthcare provider is vague, is unclear, or is non-responsive to the questions. Again, this is one reason why using the form itself is the best way and the best method for the employer to follow, since there are specific questions that need to be answered on this form. If there is any issue with the incompletion of the form itself, then the employer can go back to the employee and advise the employee that there's additional information which wasn't provided, and the employer should give the employee at least 7 calendar days to provide that additional information through his or her healthcare provider. It may arise, but probably not that often, as to whether there's a question about the authentication of the healthcare certification itself. In that situation, the employer may request authentication from the medical provider. This request should be done through the Human Resources Department, as should all information and dissemination of information and dialogue on the FMLA. The request should not be done, for example, by the employee's direct supervisor. Authentication is simply asking the healthcare provider who filled out the form to verify that the information on the form was completed and was authorized by this particular healthcare provider. In that situation, the employer should not be seeking any additional medical information from the healthcare provider, and in most circumstances there shouldn't be any issue with consent being required when the employer is only seeking to authenticate that the healthcare provider actually filled out this form and signed it. Lastly, with regard to any issues with the certification itself, if any clarification is needed, again, if there was any information that seemed to be vague, etc., then the employer should not be asking the healthcare providers for additional information beyond what's in the certification form, and the employer can, though, require the may be required, to obtain the employee's consent for clarification. Best practice is to seek the consent and authorization of the employee to have the communication with the healthcare provider for clarification of any vague responses.
I'd like to talk to you about one of the more contentious issues within the certification process, which is obtaining second opinions. If an employer receives a certification but has some reason to doubt that it's correct, it may require the employee to obtain a second medical certification. Now, when we say reason to doubt that it is correct, you need some factual basis. It can't just be that this is going to be inconvenient, or that you have a gut feeling that someone's not telling the truth. We need to be able to point to some sort of documentary evidence that there's a reason to believe that the certification may not be accurate as to either the condition or the leave that will need to be taken by the employee. Now, for second opinions, an employer can choose the healthcare provider to give the second opinion, but may generally not select a provider who they employ on a regular or routine basis. In other words, an employer should not be using a doctor or a service that conducts their physicals, provides workers' compensation evaluations, or fitness for duty certifications, drug testing, any medical provider that they have used in the past on a regular basis. Now, if the second opinion differs from the original certification, the employer may require the employee to obtain a third certification from a healthcare provider that's selected by both the employee and the employer. Now, the opinion of the third healthcare provider is the final opinion, and it must be used by the employer. The employer is responsible for paying for the second and third opinions, including any costs related to it, such as reasonable travel expenses for the employee. And while waiting for the second or third opinion, an employee is provisionally entitled to FMLA protected leave while awaiting that final certification. Now, regarding recertifications, an employer may request that an employee provide a recertification no more than every 30 days and only in connection with an employee's FMLA-related absence. If a certification indicates that the minimum duration of a serious health condition is going to be more than 30 days, then the employer must wait until that minimum duration has passed. So if someone's expected to be out 6 weeks at any given time, then you have to wait until 6 weeks has passed with an employee out on leave before seeking any sort of recertification. In all cases, though, an employer may request recertification every 6 months. For the most part, recertifications are going to be done on an annual basis for anyone that has a sort of a chronic condition that's expected to last longer than a year. But just want to emphasize that employers may seek a recertification every 6 months, but they should be careful to ensure that this is not seen as any sort of retaliatory act against an employee's leave taking. Employers may also request recertification in less than 30 days only if the employee requests an extension of the leave, circumstances described in the previous certification have changed significantly, or the employer receives information that causes it to doubt the employee's stated reason for an absence or the continuing validity of the existing medical certification. And again, an employer needs some factual basis other than a gut opinion or the fact that leave is inconveniencing them to seek a recertification within 30 days. Now, for recertifications, employers may ask for the same information in a recertification as was in the original medical certification. An employer may also provide a healthcare provider with a record of an employee's absences and ask that provider if the serious health condition for which a person is taking leave is consistent with the leave taken. In other words, if a medical certification stated that someone would need 1 to 2 days a month off and the employee is taking 4, 5, 6 days off in a month, you can ask the healthcare provider if that's consistent. And it may be, particularly with conditions that have unpredictable flare-ups. The certain medical certifications shouldn't be seen as written in stone. They are really in a medical provider's best guess and estimate, and so employers should be very careful that they're not taking the medical certifications and forcing the employee to limit their leave to the exact amount stated in the certification. Now, the employee is responsible for paying for the cost of a recertification, unlike a second or a third opinion. Now, for recertifications, an employer cannot require a second or third opinion. In most circumstances, the employer must allow the employee at least 15 calendar days to provide the recertification after their employee's initial request. Now, if an employee's need for FMLA leave lasts beyond a year, as we've discussed, the employer may require the employee to provide a new medical certification for each new FMLA leave year. And you should be aware that FMLA leave years are calculated on 2 different bases. We're not really going to discuss those today, but everyone should be aware that a simple calendar year is not going to always be the appropriate measure of the 12-month period for FMLA leave.
The last topic with regard to the FMLA certification process that we would like to discuss with you is the fitness for duty certification. Now, going back to those original notices where we discussed the various requirements and also information that should be disseminated to the employee, once they've been deemed eligible, is a fitness for duty certification. If a fitness for duty certification is required or going to be required by an employer, then the employer should have that requirement set forth in its written policies, in its handbooks, and at the very least should be including it in that correspondence to the employee so he or she is aware. It's also recommended that if it's going to be required, that it be required consistently across the board with all employees. So the fitness for duty certification would be required to be submitted by the employee then prior to his or her return to work from the FMLA leave. In general, a fitness for duty certification may not be required for each absence taken on an intermittent or reduced leave schedule. So in other words, an employee who is taking intermittent leave and is off for a few hours this day, or maybe off for a day here and there with regard to, say, flare-ups, for example, that employee should not be required to submit a fitness for duty certification for each of those intermittent absences. If the employer has a reasonable belief that the employee's return to work presents a significant risk of harm to the employee or to others in the workplace, then it may require a fitness for duty certification up to once every 30 days. If proper notice was given, an employee's return to work may be delayed until that certification is provided by the employee. And an employer may contact an employee's healthcare provider to clarify or authenticate a certification, but cannot delay the employee's return to work while that assessment is being done and making that contact. Finally, an employer may not require a second or third opinion for a fitness for duty certification. So same as a recertification, the employer should not be requiring a second or third opinion if there's if for whatever reason the employer feels the fitness for duty certification should be subjected to another medical opinion. Well, thank you very much for attending our webinar, the FMLA Certification Process, Overview and Practical Tips. Our next program will be on July 11th, titled The Potential Trouble Zone, How to Manage the Intersection of Workers' Compensation, Americans with Disabilities Act, Family and Medical Leave Act, and the New Jersey Family Leave Act. You can learn more about this program and all other Weber Gallagher events at www.wglaw.com/WG-University. Thank you.